Hi Farah, this is my lawyer, lawyer Tasha.
This is my lawyer, Akika.
Hi.
Okay, before we consult with each client, can both of you, Ima, which is the seller, and Farah, the buyer, tell us the situation when the deal of the sale and purchase happens?
Sure. Okay, so actually, sale and purchase happened when I heard Farah need oats for her racehorses. So I brought to Farah a sample of my oats from my farm, which is the green oat.
Okay, and I take a look the sample oats and that seems fine.
So at that time, you agreed that with the agreement that I will provide you 40 to 50 quarter of the oats at 34 shillings per quarter.
Yes, I agree with the agreement because it sounds like a fair deal and that's why I proceed with the order. But when I received the order, the oat was not as I expected because I specifically need all oats for my racehorses and the oat is the same green oats as the sample.
Well, Miss Farah, I thought you want a oat from this season, so I provide you what I believe that you need. And you didn't mention that you need an old oat, and then I give you order of the green oats as the sample as I assured before.
No, Mrs. Ima. Racehorses need a specific oat and green oats won't do and I can use it.
Miss Farah, I already delivered the oats as agreed upon. You owe me payment that for the first 16 quarters and the remaining order on its way.
Oh, I won't pay the oats. They are not suitable for my racehorses and I can't accept the rest of the order.
But Miss Farah, we already had agreement and I already delivered the oats as you ordered and you can back out now. So in this case, me and Farah had a verbal agreement for the sale of the oats. So Farah never specified the age requirement for the oats and I already provide what I believe that she needs.
Okay, thank you for the explanation, Ms. Ima. For Ms. Farah, may I know what your grounds for refusing the payment?
Actually, there was a crucial mistake. I need all oats for my racehorses and the oat delivered were not as agreed.
Miss Farah, can I know what's the age of the oat discussed explicitly during the agreement?
Well, no, but I assume Miss Ima understood my needs.
In the case of Ms. Ima v. Ms. Farah, the court had to determine whether the contract was void for mistake or voidable for misrepresentation. The key question was whether the parties had a mutual understanding regarding the age of the oats.
Miss Ima, I have a question. Did you knowingly provide oats that did not meet Miss Farah's requirement?
I believe that the oats that I provide were suitable. The age requirement was never discussed in that agreement before.
Ms. Farah, did you communicate your specific needs clearly to Ms. Ima?
Well, I assume she understood the standard diet for racehorses.
The court in Ms. Ima v. Ms. Farah had to consider whether the lack of explicit communication about the age of the oats constituted a mistake or misrepresentation, influencing the validity of the contract.
Okay. I heard both of your stories. So let me discuss with my client first. And Miss Ima, you can consult with your lawyer first and let's meet back after 10-minute breaks.
Okay. Okay, let's back to the case, Ms. Farah. I'm here today in relation to the charge filed by Ms. Ima. She alleged misrepresentation under Section 18.
Misrepresentation? I don't understand.
Ms. Ima claims that you intentionally misrepresent the oats you needed, leading to the financial loss. How do you respond?
I didn't misrepresent anything. I clearly told her that I need all oats for my racehorse.
We are filing a charge on behalf of Ms. Ima against Ms. Farah under Section 18 Misrepresentation Act. The core of our claim is that Ms. Farah made false statement, whether knowingly or negligently, about the nature of the oats. This induced Ms. Ima to enter into a contract based on misleading information. Section 18 states that a false statement made by one party which is relied upon by the other can render contract voidable. We contend that Ms. Farah, with her knowledge of the racehorses diet requirement, falsely believed she was acquiring old oats. This belief significantly influenced the contract. We believe that invoking Section 18 is the appropriate legal step to address the misrepresentation in this case.
Miss Ima, Ms. Farah has filed charge against you under Section 20, 21 and 22 alleging a mistake in the contract because Ms. Farah said there was a significant mistake in the agreement. What she received was not what Ms. Farah and Ms. Emma agreed. We acknowledge wherein Ms. Farah and have filed charge against Ms. Emma under Section 20, 21 and 22 alleging a mistake in the contract that led to damages and financial loss. To facilitate a thorough investigation and resolution, we kindly request that Ms. Emma and Ms. Farah to provide the detailed information regarding the specific nature of the alleged mistake in the agreement. This may include any correspondence, documentation, or evidence that can support your claim. Ms. Farah, can you elaborate on the nature of the mistake you believe occurred?
Okay, there was a fundamental mistake in the agreement. I needed all oats for my racehorses, and what I received were green oats, similar to the sample provided. The oats were not suitable for my racehorses, as I needed all oats and not green oats.
Okay. Ms. Emma, did you provide Ms. Farah with oats different from what was agreed upon?
I provide oats as we agreed, and the age of the oats was not explicitly discussed during the agreement.
Ms. Farah claims that there was a mistake. So how do you respond?
I believe there is a misunderstanding rather than a mistake. The sample of oat that I provided to Farah were suitable for the racehorses.
Ms. Farah, did you explicitly discuss the age requirement for the oats with Ms. Emma?
Well, it wasn't explicitly discussed, but I assume that she know the standard diet for racehorses.
So if it wasn't a clear mistake on Ms. Emma's part,
I believe there was a misunderstanding and the oats delivered were not what I needed.
It has come to my attention that there may be a unilateral mistake regarding the type of oat specified in the contract, and it is my understanding that according to the legal precedent, there is no duty for one party, in this case, Ms. Emma, to inform the other party, Ms. Farah, of a possible mistake. This reaffirms the long-standing legal principle of caveat emptor, which is the buyer beware. Given this legal context, it is crucial to note that a unilateral mistake, in principle, not recognized as ground for rescission of a contract. However, I believe it is in both our interests to ensure a fair and equitable resolution.
understood, Ms. Vika. So I appreciate the effort we have put into discussing and addressing this concern. It seems that we are facing a complex situation and resolving this might require more formal processes. While our goal is to find an amicable solution, I want to make it clear that we are prepared to explore all available avenues, including legal proceeding, to ensure a fair resolution. Since we didn't want to settle down the case here together, so let's hear the court's decision.
Okay.
Okay.
So, thank you.
Thank you.
Thank you for your time.
Thank you.
Thank you.